court. You do have a right to counsel. If you don't have private counsel and you'd like the services of the public defender, they are there for your assistance. If it's possible for your case to be resolved today, I will let you know. Some cases, there will be a plea offer made to resolve your case. Okay, the first case I have is, I'm calling case out of turn, Mohammed Arshad Khan.
Mr. Khan, here present, Judge Amin.
Okay, thank you. Hello, Mr. Khan.
How are you?
Mr. Khan, you have your attorney in court, and counsel, what's your name for the record?
Adam Geller on behalf of Mr. Khan.
Okay. So, Mr. Khan, you're here on a domestic battery by strangulation charge, domestic violence battery, and harassing a witness or victim. The court does find probable cause. Mr. Geller, do you wish to be heard?
Yes, Your Honor. I would just point out that the probable cause affidavit doesn't indicate any attempt to speak to Mr. Khan as far as his side of the story. But besides that, I would just ask Your Honor to consider a pretrial release program. Mr. Khan's lived here since 1982. He's a U.S. citizen. He's got 4 minor children. He does have a place to stay with friends and family that's not at the house where the alleged victim lives. He's got no priors and obviously no history of failure to appear. And he drives for Uber since losing his job with the phone company. So I know that Mr. Khan doesn't have the availability of funds if the bond were to be, anything high.
Okay, thank you. State?
Yes, just briefly, Your Honor. Just briefly in response, I'm sure the law enforcement would have wanted to talk to Mr. Khan, but according to this, he fled the area in his car before they arrived. Your Honor, he does not have a criminal history. That being said, I am concerned based on the level of violence alleged in the report. The state would be requesting a $10,000 bond on 1, $5,000 bond on 2, and a $2,500 bond on 3, with an order of no victim contact.
Okay, and what's the state's objection to releasing him on pretrial if he has no priors?
Well, one, Your Honor, I think in any case where there's an allegation of strangulation, I just think that's too violent a charge for a straight ROR release to pretrial, Your Honor. Additionally, the battery, even though it's a misdemeanor battery, it appears to be a higher level of violence just going by the injuries that the officer noted that the alleged victim suffered. And lastly, Your Honor, there's also a concern anytime somebody's trying to call 911 for help and the assailant prevents them from even trying to get help from 911.
Okay. I'll tell you what I'm going to do under the circumstances. I've read through the probable cause affidavit. The court is going to refer Mr. Khan to pretrial with certain conditions. Number 1, you're going to have an ankle monitor. It's going to be level 2. Does not allow him to leave the house?
Level 1 locks him down.
Okay. It's going to be a level 1 ankle monitor. According to the probable cause affidavit and your counsel, you're not working. You're presently driving for Uber. But this is going to have to be a level 1 ankle bracelet. You are to have no contact with the alleged victim. That means you need to leave the premises. And that's it. Okay, so explain to me, I'm releasing him to pretrial. If he violates pretrial, are you asking why do I need to set a bond? What? If I set a bond also, he would have to pay the bond and be on pretrial? Okay. No, I'm going to ROR him.
Thank you, Your Honor. And as far as the address where he's going to stay, I guess he could provide that to the program. Okay, I'll get that. Okay, and okay, and where would I provide that? You'll have to provide it. Okay.
Okay, and I'm just going to announce.
He does. I don't have the address at this time, but I know we've spoken with family and friends, and they're going to allow him to stay there.
And he knows how to. He has their contact information, so that when we speak with him, when it's time to put the minor on, he'll be able to provide all of that.
I'm not sure if he's got their contact, but I can.
Mr. Khan, do you have the contact information for where you're going to be staying?
Not yet, but I have to contact.
Okay,
Okay.
Okay.
Just says that he didn't
Thank
All
you,
right.
Your Honor.
You're welcome.
move from his last location. He's in arrears.
Alyssa LaShawn Blue.
Yesterday, this was signed April 3rd.
Ms. Blue is here present, Judge Main. She's approaching.
Your Honor, the victim is present.
Okay. Who's here for Alyssa Blue?
This gentleman right here, Your Honor, Mr. Samuels, is that correct? Would you
Mr.
like to
Samuels,
address
would you
the
like to
court?
come up? Ms. Blue, you're here on a domestic violence battery charge. The court does find probable cause, and you have someone in court here. Are you Ramita Samuels?
Yes, ma'am.
Okay, what's your relationship with Ms. Blue?
That's my girlfriend.
Okay. Is there anything that you'd like to say to the court?
I'd like to say it was just a misunderstanding, and that I'm not trying to mess up her life, and I don't want this to mess up her life.
Okay.
And she's trying to do a lot in life, and this is going to hold her back.
Are you in fear for your safety?
No.
Okay, and State, what is your recommendation as far as bond?
Showing she was arrested in the state of Georgia earlier this year for battery and robbery. Those charges were dropped. Also noting that there was an independent witness that observed the allegations in this matter. I would just be requesting a $1,000 bond and no victim contact.
Okay. The court's going to issue a $1,000 bond, and I'm going to order, because Mr. Samuel is indicating you'd like to still have contact with Ms. Blue, the court's going to order no harmful contact.
Judge,
Yes.
if the defense could be heard, my understanding is, and speaking with Ms. Blue, she's 22 years old. She's been residing in South Florida her whole life. As the state confirmed, she has no prior filed cases or convictions or anything like that. My understanding is she is working. She works for Johnny's Towing. She just started her employment. She works there she's been working there for about 3 months now, making only $60 a day. She does have ties to the community. She's a graduate of Coral Springs High School, class of 2012. I would ask you, considering her financial resources, Judge, no sort of prior convictions. You heard from the victim himself. He had no sort of, he said it was misunderstanding, no sort of concerns. Judge, we'd be asking you to consider an ROR, and we do understand, Judge, since this domestic situation, if Your Honor still wants to impose a no contact order, she does have a separate place to live. She has members of her family that live in our community in Broward. She could go and stay with them to alleviate any of the court's concerns. But at this time, we'd be asking you to consider an ROR.
Okay, and State, tell me, you said she had a
She had an
prior arrest?
She had an arrest in January this year, but one of the counts was for battery, even though it was dropped. Your Honor, it's her second arrest for battery this year. I do think some bond is warranted.
Okay, under the circumstances, since she has had a prior arrest and the allegations that I see in the probable cause affidavit, I am going to leave a $1,000 bond and no harmful contact with Mr. Samuels.
Yes, sir.
Good luck.
So I'll be able to see her, talk to her, whatever.
If you yes, you can. Katera,
You can also post her bond if you wanted to.
I'm going to post a bond.
all right, you got it.
Good luck.
Your Honor,
Katera Bullard,
just, if it's okay, after this case, if we can call a case out of turn, please.
absolutely. Hello, Miss Bullard. Hello. Miss Bullard. You're here on a domestic violence battery charge. The court does find probable cause.
In regard to that, Judge, if I may.
Yes.
Yeah, in reading the probable cause affidavit and a quote from the arresting officer, he says, I was unable to determine the primary aggressor. Both Kandarius and Katerina have physical injuries, at which point they both denied fire rescue. It seems like the officer himself was unable to determine exactly what happened here or who the primary aggressor was. So I don't think there's probable cause to hold Miss Bullard on that charge, absent a finding that she is the primary aggressor.
What's the state's position?
Even if the court accepts that, then the court can still find probable cause for disorderly conduct, which prohibits brawling or fighting. Yeah, I just got
Okay. Without a determination as to who was the primary aggressor, the court is going to find no probable cause for a domestic violence battery, but I am going to find probable cause for disorderly conduct. What is the standard bond on that charge?
I believe it's a second-degree misdemeanor. Mr. Leonard, if you can correct me, I believe it's $100.
I think it's 25.
Oh,
$25?
It is, Your Honor, and we just asked the court to take into consideration this disorderly conduct involved violence, and she also has a grand theft and resisting without violence.
All right.
I'll leave the bond at the court's discretion. I'm just asking for a no contact order.
I am going to enter a no contact order with the alleged victim, Kadarius Hope.
and the bond, $25?
$25.
Thank you.
Thank you, Judge.
Okay. Ms. Linda, what's the case?
Stephanie Pantoliano on page 10.
She's in North Broward, Your Honor.
Okay. Hold on, let me get the case. Stephanie Pantoliano. Hello, I am just finding your case. One moment, ma'am. Okay, here we go. Stephanie Alexandra Pantoliano. Okay.
Good morning, Your Honor. Ross Weiner on behalf of the state.
Oh, good morning.
Good morning, Your Honor.
Okay, Ms. Pantoliano, you're here on not in custody capiases that were issued for 2 counts of DUI causing death, and you have 5 counts of DUI with property damage. Okay, and what is the state wish to be heard?
Yes, Your Honor. Do you have a copy of the PC?
Let me take a look here.
No, Your Honor.
I do not have a copy of the PC.
Your Honor, may I approach with a copy?
Yes. Thank you.
Your Honor, I'm handing the court and counsel
Yeah.
a copy of the probable cause. Attached to that is also the state's motion for pretrial detention. Once the court has a chance to review the probable cause, I could address the motion.
Okay, give me one moment. Okay, so explain to me why there are 2 counts of DUI causing death. There was one fatality.
The state has the ability to charge DUI 2 ways, one with an unlawful balance and one based on impairment. And the state can charge that 2 separate counts. So the first count is based on the unlawful balance of the .20 blood, and the second count is based on her defendant's impairment. So the state has the option to either combine them into 1 count or charge them as 2 separate counts.
Okay. All right, and let me hear, actually, Ms. Pantoliano, the court does find probable cause for these charges. What is the state's recommendation as far as count 1 and count 2? It appears there's no bond on counts 3 through 7. Is that something that the court is
I'm
going to
not
set?
sure why it's showing no bond. It should all be no bond held for magistrates. That might have just been an error the way the capias was issued.
Okay.
But I've also handed the court the state's motion for pretrial detention. Under Florida statute 907.041, if a defendant is charged with DUI manslaughter and has a prior conviction for DUI, the state is able to file this motion. Based on that statute as well as Rule of Criminal Procedure 3.132, I've attached both the statute and the rule for the court. If the court finds probable cause that the defendant has committed the DUI manslaughter, the court must hold the defendant no bond, and we do have to set it for a pretrial detention hearing before the division judge, Judge Merrigan, within the next 5 days.
Okay, and what about for counts 3 through 7?
I believe everything's supposed to be no bond until it goes before Judge Merrigan, and then Judge Merrigan will.
Okay. Does the public defender wish to be heard?
Judge, I've reviewed the statute. I'm familiar with it. I know the court has made a finding of probable cause. I think the statute specifically discusses this particular type of offense, and I would ask that this be set down in front of Judge Merrigan as soon as possible. I thought it was 3 days, not 5 days, Mr. Weiner.
It says 5 days in the rule.
Okay. All right. I think it would be best to get Ms. Pantoliano in front of Judge Merrigan as soon as possible to resolve these issues.
Okay.
All right.
Thank-
And just for the record, Judge, she has lived here all of her life. She does have a lot of family here. She has 3 children, and she's given me her mother's number. I'm going to call her mom.
Okay, thank you. So, Ms. Pantoliano, pursuant to Florida Statute 907.041, subsection 4C4, the court is going to hold you for pretrial detention, issue no bond at this point in time on the charges. And as you heard your public defender's office make an argument, you will be brought before the trial judge within 5 days for a bond determination. Good luck, ma'am.
I'll be following up on that to make sure that happens, ma'am.
Consistent this morning to set the hearing within the next 5 days.
Thank you. I appreciate
Mr.
that.
Weiner,
Yeah, I'll CC you on the email.
Frank Hernandez. Mr. McLawrence, why don't you tell the clerk, you have a number of cases here?
Just 2. I already provided them.
Oh, you did? Okay. Mr. Hernandez, you're here on a capias. You have a $2,500 bond. It's a violation of an injunction. You are set to go to court. You will be set to go to court. Right now, you don't have a court date yet, but $2,500 bond. Good luck. Mr. McLawrence, how can I help you?
Good morning, Judge.
Good morning.
Page 8 of your docket in North Broward, there's Joanne Balkunas, and she's here on the City of Fort Lauderdale Municipal Ordinance violation of alcoholic beverage possession.
Okay, hold on. Let me get her
And
here.
I'm sorry, possession of drug paraphernalia and alcohol beverage.
Okay, Joanne Balkunas. Hello, ma'am.
How you doing, ma'am?
Well, okay, so you are here on 2 municipal ordinance violations, a drug paraphernalia and alcohol violation. The court does find probable cause. You have bonds set in the amount of $100. Would your client like to resolve the case?
Yes, Your Honor, and I spoke with her this morning, and she expressed to me that she's willing to plead no contest if the court would offer her a time-served sentence.
Okay, State, does she have any priors?
Your Honor, she had a municipal ordinance February of this year soliciting prostitution in '98, and there's a hit out of New Jersey Shoplift.
Kunis, please don't speak.
Okay.
A few shopliftings.
The court will offer an adjudication time served. You want to resolve your case, Ms. Balkunas?
Please.
How do you plea?
No contest.
The court's going to accept your plea of no contest. The court's going to adjudicate you guilty, sentence you to time served on each of the charges. You're all set. You'll be released.
Thank you.
Thank you, Your Honor. Judge, and lastly, on page 4.
What? Yeah, court costs go with that.
On page 14 of the
Always.
docket, Your Honor, there's Narayana Ari, and he's in the main jail.
Okay, thank you. Thank you. Hello, let me just get your case here. I'm sorry, his last name is?
Ari, A-R-Y.
Last name is Ari. Here we go. Okay, Narayana Ari. Now, you're here on a municipal ordinance violation for solicitation. The court does find probable cause. Would your client like to resolve this case?
Yes, Judge, I met with him this morning, and he expressed to me that he'd be willing to plead no contest in exchange for a time-served sentence as well.
Okay. The court's going to offer adjudication time served if you'd like to resolve this case.
Yes, ma'am.
How do you plea, Mr. Ari?
No contest, Your Honor.
The court's going to accept your plea of no contest. The court's going to adjudicate you guilty, sentence you to time served.
Thank you.
You're welcome.
Thank you, Judge.
You're welcome.
Thank
Mr.
you,
Collins.
Mr. Lawrence.
You're welcome. Have a great weekend, everyone.
Godfred Rubstick.
Mr. Rubstick's here present, Judge, at Maine.
Thank you. Hello, Ms. Rubstick. You're here on a domestic violence battery charge. The court does find probable cause.
In regard to probable cause on Mr. Rubstick's case, Judge, I would point out the probable cause affidavit indicates, and this allegation is based solely on the testimony of Ms. Young, who's the alleged victim in the case. According to the officer's report, Ms. Young was incoherent at the time he spoke to her. Mr. Rubstick stated to the police that she attempted suicide. She tried to
Your Honor,
drink.
I'm going to object. Just as Mr. Reedy would want, if there were mentions of that type of thing regarding a defendant, he wouldn't want to necessarily broadcast over the internet. I think the same deference should be shown to an alleged victim. He can make reference to the report.
I don't disagree, Judge. I think
Okay.
that Mr.
I do agree with Mr. Linder.
I agree with him as well. The court can read exactly what happened as far as Ms. Young's physical condition is concerned. My concern about the probable cause is that it does say she was incoherent. And the only allegation, the only evidence at all against Mr. Rubstick is that testimony of a person who was in that condition that Ms. Young was in. I find that to be extremely unreliable for finding a probable cause, and I would ask that the court not find probable cause in this case.
Okay.
Judge, the only thing I wish to add, and I don't know if the PC indicates that, is that Mr. Rubstick was the one that actually called law enforcement out of his concern for his girlfriend's condition.
Okay, I've read through the complaint affidavit, and I believe the argument that's been made by the Public Defender's Office goes to the weight of the evidence, not a finding of probable cause. The court does find probable cause. I am setting bond in the amount of $2,500 and ordering no contact with the alleged victim, Naomi Young.
Judge, would you sign a phone order allowing Mr. Rubstick access to his phone so he can call someone for purposes of placing that bond?
Yes, your request is granted. Quentin Lee Jackson.
Mr. Jackson's approaching, Judge?
Mr. Jackson, hello. You're here on two bench warrant charges, one for battery, one for criminal mischief. You have bond set at $3,000, and you're going to be going to court to see if you can resolve those cases. Good luck.
Thank you.
Mark Falugo?
Conti, Your Honor.
Thank you. Mr. Falugo, you're here on a criminal mischief charge and violation of a injunction. The court does find probable cause. You have bond set at $500 on count 3. These are ad charges. The the criminal mischief, and on the injunction violation, court is setting bonds in the amount of $7,500 and ordering no contact with the alleged victim, Melissa Ann Johnson.
In regard to count 4, Judge, I don't recall seeing in the probable cause affidavit an indication that Mr. Falugo was ever served with that injunction.
She has a active no contact order and an active injunction.
There's no indication that Mr. Falugo was aware of that, as there's no indication that he was ever served with it.
What's the state's position?
I could just have one moment, Your Honor. Your Honor, I can, if I can just have one moment, I can provide the court with proof of service.
I would argue that that is beyond the 4 corners of the probable cause affidavit, and even if the state can produce evidence that the injunction had been served on Mr. Falugo, that is still not part of the probable cause affidavit. And the court would be going beyond the confines of that document and finding probable cause based on things that are not contained in the affidavit itself.
The court is not bound by the 4 corners. For instance, live witness testimony, what I'm referring to, Your Honor, and I don't know if you have access. I could direct the court if you have access to Odyssey on the computer.
I do.
The civil case, it is part of the court record, which I think the court certainly can rely upon. If Your Honor can go under the civil search, I can give the court the case number.
Hold on.
Sure.
It's not allowing me to get onto Odyssey. Hold on. Let me see
Oh.
if there's another way. Oh, okay. I got it. I don't think this. Okay, here we go. Okay, what's the case number?
It's okay. It's going to be DVCE -16 -1698. That's actually, you know, one moment, Your Honor. I just have one moment. I'm sorry. Just need to make sure something. Okay, sorry. Here, actually.
Okay, I do see that there was a final judgment on an injunction that you filed in 2016. There was a order of dismissal and then an affidavit of violation.
And what I'm checking to see on the order of dismissal, because there was also a counter injunction. So, yes, if you look at the order, because, Your Honor, here's what happened. Mr. Falugo sought the injunction initially. He's the initial petitioner. But if you go to the Ms. Falugo, or Melissa Johnson, she filed a counter injunction. And if you go to counter final judgment on injunction, you'll see that it was issued. It was granted for her.
Okay.
Now, the dismissal, for the court to order of dismissal, that applies to, as you can see, it says, petitioner appeared at hearing but desires to voluntarily dismiss his action. Mr. Falugo was the original petitioner. That refers to his...
I understand everything you're saying. Mr. Falugo, just in case you forgot, there was an injunction that you filed against your wife back in 2016. There was a dismissal that was entered back on April 12th, 2016. Your wife filed a counter injunction which was entered against you on April 12th, 2016. So there is an active injunction. You did have notice. What's the state's recommendation for bond?
Your Honor, well, I'm fine with the 7,500 the court said, just to let Your Honor know, on counts 1 and 2, he's being held court-ordered no bond on charges of grand theft and battery.
Okay. Good luck, Mr. Falugo.
Thank you, Your Honor.
Okay.
All right, good luck, man.
Demetrius DeMonte Jewel. Thank you. Hello, Mr. Jewel. Mr. Jewel, you're here on a domestic battery by strangulation charge, a domestic violence battery, and resisting without violence. The court does find probable cause. I am setting bonds on count 4, the strangulation in the amount of $20,000. On the domestic violence battery, bond is set at $5,000. The court is ordering no contact with the alleged victim, Christina LaShawn Dwyer. Good luck, sir. Doran Cortez Tate.
Mr. Tate, approaching judge, can you hear me?
Okay, Mr. Tate, you're here on a domestic battery by strangulation charge, domestic violence battery, and tampering. The court does find probable cause. I am setting bond on count 1 in the amount of $20,000, count 2, $5,000, and the tampering will have a $1,500 bond. The court's ordering no contact with the alleged victim, Hilda Marie Tate.
Judge, if the defense could be heard.
Yes.
I'm seeing Mr. Tate. He's 32 years old. He's been living in South Florida in our community for over 20 years. He is currently employed. He works for a company called Sierra Tree Service. He's been steadily employed with the same company now for about a year and a half. He doesn't get paid hourly. He gets paid by the day, $100. So whenever there's no work, he doesn't get paid. Financially, though, he has no money in the bank, no property. He sees that he's trying to better his future. He enrolled in Florida Career College. He's right now working on their HVAC program. He's scheduled to complete that program this year, so that's going to lead to better work opportunities. The alleged victim in this situation is his wife. He does understand, as far as your order, no contact. He will be living separate and apart. He does have members of his family that live in our community, specifically his mother, that he'll be living with, and she lives in Fort Lauderdale. Judge, he did advise me that his mother is going to be the only person that could potentially post his bond, but she doesn't have a high-paying employment or anything like that. The $10,000, $5,000 on counts 1 and 2 respectively is something that he nor his family can afford. We'd be asking you to consider setting a $5,000 bond on count 1 and a $2,500 bond on count 2, Judge.
Okay, let me hear from the state.
I'm asking the court to keep the bonds that you set in place. Mr. Tate's history: in 2015, he was arrested for domestic violence battery by strangulation and felony battery due to priors against the same alleged victim. Those charges were null prost. He was arrested in 2013 for battery against the same alleged victim. That was null prost. He was convicted of battery against a different woman in 2010. 2008, uttering a forged instrument and grand theft, 3-year state prison. 2008, shooting at or throwing a deadly missile. He was convicted and sentenced to 3-year state prison. 2005, possession of marijuana with intent to sell or deliver.
All right, Mr. Tate, I'm reviewing the allegations that are contained in the complaint affidavit, which are really very troubling to the court. It says here that you came home and you asked your wife to shut the door so the children don't hear you argue with her, and that you got on top of her and beat her. She pleaded for you to stop. You had your hands around her neck, and you had a 13-year-old daughter that was in the house that didn't see anything but heard You state, I will beat your ass. The courts also heard from the state as far as prior charges that you had that were null prost. I do understand it was against the same alleged victim in this case. The court is going to leave the bond set at what I stated. The court is inclined to increase the bond, but I am going to leave it set at $20,000 on count 1, $5,000 on count 2, and $1,500 on count 3. No contact with your wife. Marlon Wilson.
Your Honor, we have a witness here on Mr. Wilson's behalf, and that
Okay.
would be Katina Smith.
Hello, Mr. Wilson.
Good morning. How you doing?
Well, okay, you have a lady here named Katina Smith. Ma'am, what's your relationship to Mr. Wilson?
We've been dating for almost 4 years.
Okay, so your girlfriend is in court, and you are here on a domestic violence violation of injunction, and you have an out-of-state hold. Okay, hold on one second. Okay, and the two of you, it looks like, went on a cruise together.
Yes, ma'am.
Anything you wish to say to the court?
Well, first of all, yes, we're here. We're from out of Louisiana. We were going on a cruise. I didn't file a restraining order against Mr. Wilson. In fact, I didn't even know about it. Had I known such, or we knew, I definitely wouldn't bring him over here. He agreed to come with me. As far as the warrant back in Louisiana, that's for his arrest. There was a misunderstanding about my cell phone. This happened about 3 months ago. He returned my cell phone the very next day. So he hasn't been arrested for that. In fact, regarding the domestic abuse, a couple of months ago, it was also a misunderstanding. And he has an arraignment on the 15th where we were going to rectify that. It was an argument that turned into, he's not violent, Your Honor. I'm not afraid of him. I have over 8 years of domestic violence experience. I was a former director for our local program. And I'm a licensed therapist, so I'm not afraid of him. I mean, I can't even believe and beat myself up that I even put him in this.
Okay, I appreciate you advising the court. State, what's your recommendation for Mr. Wilson?
And here's the thing, with the out-of-state hold, he's not going to be brought to Louisiana until the count 1 is resolved one way or another, whether it's no info or if it's pled out. So this is one of those situations where if you weren't to, it would actually probably harm him by not giving him a bond than by giving him a bond, because he wouldn't get gain time and he can't get out anyways at this point in time. And as far as the no contact order, I understand what Ms. Smith's saying, but and I'm sure it's attached to your paperwork. It does appear that there is a active restraining order, so I would just ask for, I mean, it's probably a moot issue, but a no contact order at this point in time, all that injunction is still in place. And whatever, and if the court's inclined to set a bond, I'll leave in the court's discretion.
Okay, let me hear from the public defender, please.
It's obviously a difficult situation, Judge. I know there's nothing you can do about the no bond hold out of Louisiana. And I agree with Mr. Linder. If you were ROR, Mr. Wilson, he wouldn't be getting credit for time served, and he wouldn't be released from jail in any event. I think the only thing we can do is maybe encourage the Office of the State Attorney to make a filing decision on this charge as soon as possible. Personally, I don't see, it might even be a jurisdictional issue if this warrant is out of Louisiana, that the violation actually occurs in Louisiana from her having contact with him or him having contact with her, and not a Florida case. I don't think that's an issue we're going to be able to resolve this morning.
What's your recommendation as far as setting bonds on count
Maybe
1?
the court would care to hear from Mr. Romero on that issue.
Mr. Romero?
Judge, I've been talking right now to Mr. Wilson as far as the difficult situation he's in at this time. And Mr. Linder is correct in saying I don't know if an RR at this point may potentially have negative impact on him because Louisiana isn't going to pick him up. I'd ask you to set a nominal bond at this time of $100.
Okay.
I concur with that.
Okay. Ms. Smith, let me explain something to you. Your boyfriend is being held. Could you turn there's tremendous feedback. Could you turn the volume down? At the main jail? Yes. Hold on. Could you hear me?
I just put on mute, but nobody was talking. I think it was the other jails, Judge.
No, I'm getting feedback here where I'm hearing myself echo. All right, turn the volume back on. Okay, so Mr. Wilson has a problem because he has an out-of-state hold. He's being held no bond. If he's released on the domestic violence injunction, if he's ROR'd, he's not going to get credit for any time that he spends in jail, and he's going to be spending time in jail on the out-of-state hold. So what I'm going to do in this situation, I'm going to issue a bond in the amount of $100 on count one. I'm going to order, I have to order at this point in time no contact with Ms. Smith because there is an injunction. So until you have that lifted, at this point in time, you have to have no contact.
Apparently, there was something that he was given when he was released from jail the day that he got arrested. It wasn't something that I did.
Okay.
It's something I could do if I felt the need, but I'm not afraid of him.
Okay.
He's not threatening me. It was a misunderstanding over an argument that day.
I understand,
Yeah.
but you're going to need to talk with somebody at the state attorney's office and have that injunction removed if it was issued in error. All right. Good luck, Mr. Wilson.
Thank you, Judge.
You're welcome. Charles Simpson.
Mr. Simpson, come on up, please.
Mr. Simpson, you're here on an aggravated assault with a deadly weapon, domestic violence, and possession of a weapon by a violent career criminal. The court does find probable cause. I'm setting bond on count one in the amount of $10,000. Count two has a $250,000 bond.
And, Your Honor, in fairness, and I'm looking at the officer's report, and the last sentence is, it appears the officer's intent was to charge him with a convicted felon in possession of a firearm and not a violent career criminal. It's possession of a firearm by a convicted felon is a no bond hold for magistrates, but it's not a first-degree felony. So I have no objection to the court setting a much lower bond on that.
Okay. All right, Mr. Simpson. The Assistant State Attorney has advised the court of a correction. I'm going to change the $250,000 bond. I'm going to give you a $5,000 bond on count two. Good luck, Mr. Simpson.
Sorry, and, Your Honor, and I apologize if you already did. Did the court order no victim contact?
No, I didn't. The court's ordering no victim contact with LaShunte Lancaster. Candarius Hope.
Judge, my only request to Mr. Simpson is would you sign a photo order?
I will.
Thank you, Judge.
You're welcome.
Good luck, sir.
And I'm just going to ask.
Okay, Mr. Hope, you're here on a domestic violence battery charge, and you have 2 violation of probation warrants. The court does find probable cause.
Actually, Your Honor, I'm sorry. This is the co-defendant from we had earlier. We found for disorderly conduct, so I have no objection to the court making the same findings.
Okay, Mr. Hope, I've just been advised you have a co-defendant that was on this docket also. The court is going to make a finding that there's no probable cause for domestic violence battery, but I am going to make a finding that there's probable cause for disorderly conduct. I'm going to issue bond in the amount of $25 on that charge. You are being held no bond on the probation violation, but you're going to court May 31st. Good luck.
Good luck, sir.
Giordani Dahel.
North Broward, I believe.
Thank you.
That's going to be a medical reset.
Okay, thank you. Okay, Nixon Ward, I understand, is also a medical reset.
Medical on, yes, Judge.
Okay, we'll reset Mr. Ward. Jabari Matthew Bailey.
Mr. Bailey, come on up, please.
Hello, Mr. Bailey. Mr. Bailey, you're here on an out-of-state hold. There's currently no bond set. But you should be extradited back to the state you have these charges. Good luck. Marlo Rafael Marino. Mr. Marino, you are here on an out-of-state hold. There's currently no bond. You will be transferred to the state which has your case. Good luck. Sally Virginia Rose.
North Broward, Judge? North Broward, Your Honor.
Thank you, Deputy.
Rose. Stand on the edge. Who's Rose?
All right, Miss Rose, you're here on a violation of probation warrant. There's a no bond hold, but you will be going before Judge Gottlieb to resolve this matter. Good luck. Brianna Marie Wilson.
North Broward, Your Honor.
Hello, Miss Wilson.
Yes, ma'am.
You are here on a false ID given to law enforcement and possession of drug paraphernalia. The court does find probable cause. You have a $100 bond. State, is there an offer you can make, Miss Wilson? You want to resolve your case, Miss Wilson?
Should be able to.
I don't know that even knows really.
What?
I don't have anybody that will help me, yeah.
Do you want to resolve your case?
Yeah.
Okay, let's find an offer.
Your Honor, the state's offer be adjudication time served on 1, withhold court costs, judicial notice of time served on count 2.
Okay, if you'd like to resolve your case, Miss Wilson, the offer on the false ID is an adjudication and time served. And on the drug paraphernalia, it would be a withhold adjudication, which means it's not a conviction, and you would pay the court costs. Would you like to do that and resolve your case today?
Yes, ma'am. Can you explain what that means to me? Because I don't understand.
That means your case will be over. You'll be released. You will have to pay the court costs. And I'm going to give you 6 months to pay the court costs, but your case will be over. You want to do that?
Yes.
How do you plea?
Guilty.
Okay, the court's going to accept your plea of guilty. The court's going to adjudicate you guilty, sentence you to time served on count 1, withhold adjudication, impose court costs, and the court will take judicial notice of time served on count 2, and we'll give you 6 months to pay. All right, you're going to be released, Miss Wilson.
Okay, thank you.
You're welcome. Allie Elizabeth Lutz.
North Broward, Your Honor.
Thank you. Now, Ms. Lutz, you're here on a trespass charge, and you have a capias. The court does find probable cause. You have bond set at $525. Would you like to resolve your case?
Yes.
All right, State, can you make an offer on each of these counts? The capias is for
Yes, Your Honor, she has
solicitation.
she has a prior possession of cocaine, so my offer would just be adjudication time served both counts.
Okay. The state's offers an adjudication and time served on each of your cases if you'd like to resolve your case.
Yes, Your Honor.
How do you play?
Guilty.
The court will accept your plea of guilty. The court's going to adjudicate you guilty, sentence you to time served on the trespass charge. The court's going to adjudicate you guilty, sentence you to time served on the capias, which was a obstructing traffic charge. We'll give you 6 months to pay. And you're all done with your cases. Good luck.
Thank you.
You're welcome. Margaret Payne. Hello, Ms. Payne.
Good morning.
Ms. Payne, you're here on a trespass charge. The court does find probable cause. I'm going to see if we could resolve your case today. What's the state's offer?
One moment, Judge. State's offer just be adjudication time served.
All right. If you want to resolve your case, the offer is an adjudication and time served. Would you like to do that?
Yes, Your Honor.
Okay. How do you plea, Ms. Payne?
No contest.
The court will accept your plea of no contest. The court's going to adjudicate you guilty, sentence you to time served. All right, you'll be released.
Today?
Yes.
Thank you very much, sir.
You're welcome. Hasta Rudy Ferreros Campos.
Yes.
Good morning, Your Honor. Ms. Campos is at the poll round.
Okay, thank you. Ms. Campos, you are here on a petty theft charge. The court does find probable cause. Would you like to resolve your case?
Yes, yes.
All right, could the state make an offer?
Offer be adjudication time served. She had a theft last year.
Okay, so the plea offer is an adjudication and time served. Otherwise, you have a $25 bond.
Okay.
Do you want to resolve your case?
Yes.
How do you plea? If you want to resolve your case, it's a plea of guilty or a plea of no contest. Ms. Campos, I'm going to need for you to answer.
Yeah, guilty.
Okay, that means you're resolving your case today.
Yes.
The court will accept your plea of guilty. The court will adjudicate you guilty, sentence you to time served, and you will. Yes.
I apologize. Just a couple things I would ask the court to advise Ms. Campos of. One, since this will be her second theft, if she picks up a third theft-related offense, she could be charged with a felony theft. And also, I'm seeing that she's born in Brazil, so I would just ask that the court could advise her.
I will.
She's not a U.S. citizen. Thank you.
Ms. Campos, a couple of things you need to understand. This is your second theft charge. If you get arrested one more time for any kind of theft-related charge, it could be filed as a felony. So be aware of that. And I also need to advise you that if you're not a U.S. citizen, a plea of guilty or no contest may subject you to deportation. Do you understand? If you don't want to resolve your case today, I will vacate the plea and you'll have a $25 bond.
I know it's this.
Okay, let me tell you what.
I have to pay $25.
No, you need to understand that if you're not a U.S. citizen, by resolving your case today, pleading guilty or no contest, it may subject you to deportation.
No, I don't want this.
Okay, then I'm going to vacate the plea that you entered and leave a $25 bond. All right, good luck. You're welcome. Brittany Leanne Christian Allen. Okay. Brittany Leanne Christian Allen.
I've been advised she bonded, Judge.
Okay, thank you. Rachel Janae Sims.
And I've been advised she bonded as well, Judge.
Thank you. Olesa Sandstrom.
Ms. Sandstrom is approaching here. She's here at me.
Okay, Ms. Sandstrom, you are here on 2 violation of community control warrants. You have a no bond hold. However, you are going to court on May 31st to address these charges. Good luck. Amanda Flores. Amanda Flores. Is Amanda Flores up at North Broward?
I showed her at Maine.
Okay, I'm not getting any response. I need to see Amanda Wendy Flores.
Judge, I've been advised she bonded.
Oh, okay, very good. Thank you. Yvonne Latoya Reed.
Ms. Reed is here present, Judge.
Okay. Hello, Ms. Reed. You're here on a grand theft charge. The court does find probable cause. You have a $1,000 bond.
Thank you, Judge.
You're welcome. Lauren Valine Hunter.
North Broward. North Broward, Your Honor.
Thank you. Hello, Ms. Hunter.
Hi.
Ms. Hunter, you're here on a distribute or delivery of heroin charge. The court does find probable cause. You have bond set at $2,500. Good luck. Taylor
Judge, regarding Miss Hunter, she's been living here all of her life.
Hold on, Ms. Hunter.
Yeah.
Your attorney from the public defender's office is speaking. Hold on.
Yeah.
She's been living here all of her life, Judge. She's currently studying cosmetology. I don't know what the state shows for a prior record on her, but she can stay with her father. She does, so she does have a stable
No,
residence.
that's Taylor. That's not me. That's my sister.
Oh, okay. Sorry.
Okay, we're talking about Lauren.
Okay. Are you going to be able to? Where are you going to be able to stay, Lauren?
I have my own place
And how long have you been living there?
since February.
Okay.
Say, does she have any priors? For what?
So she had a arrest for domestic violence, aggravated battery, great bodily harm. It was declined yesterday. I'm just checking to see if there's anything else.
So I have to pay the bond before I get out?
Hold on.
Hold on just a second, Lauren. We're trying to determine what an appropriate bond in your case might be. Do you have someone to bond you out?
No, I don't.
You going to be able to bond yourself out?
No, I don't have any money.
Your Honor.
Yes.
And could we go to sidebar? And obviously, Mr. Reedy can advise Ms. Hunter what I'm going to tell the court. I think it's relevant, but I would rather not have it broadcast over the internet. I think the court should just be aware at least.
Stand by, Ms. Hunter.
Okay, the court's going to allow the attorneys to approach sidebar.
Well, I don't think we have to approach. We have to approach. It's just when you hit sidebar,
Off the record.
It just won't be. It's on the record. It just isn't broadcast over the internet.
Turn the system off.
No, you don't have to turn the system. No, it has to be. It has to be a transcript. It's just when you hit sidebar, it's not broadcast over the internet. Your Honor, I'll leave it in the court's discretion. I just think if she is going to be, if the court's going to consider a release to pretrial, that maybe there be some kind of mental health component also included.
The court is ordering that you have a mental health evaluation and any follow-up treatment that is recommended. You understand?
Okay, so how do they verify my address?
Pretrial? How do...
She'll give us a name of someone who we can use to verify her address, or you will travel to.
Okay, they will either physically travel to your home or have to speak with somebody that could verify your address.
My sister lives with me. Your sister lives in custody? Could that be verification?
No.
Anybody else?
Maybe my case manager, but I don't know his number by heart.
Okay, very good. Well,
Okay,
you'll
they'll
be
check
released
with your. I'm
pending
sorry, Judge.
verification.
They'll check with your case manager to verify your address. Okay.
Thank you.
Okay. Good luck, Lauren.
Okay, Taylor Ann Hunter. Hello, Miss Hunter. Okay, so you are Lauren's sister, correct? Okay, so you're also here on a distribute or deliver heroin charge. The court does find probable cause. You have bonds set in the amount of $2,500. State, does she have any priors?
I'm sorry, I'm trying to find. I don't have her paperwork for some reason.
Taylor Ann Hunter. Okay. Does the state have any objection to pretrial release pending verification on her?
No, Judge.
Okay. Ms. Hunter, the court's going to release you to pretrial release pending address verification. In the alternative, there's a $2,500 bond.
Also, I would have to speak with my father to go back to his house. I don't know his new number.
Does the second
Do you reside in the Tri-County area?
Yes, ma'am. He lives in Plantation.
Okay. Okay, very good. They're going to try and verify your address to be released.
Judge, I'm going to
pretrial.
ask you to sign a order authorizing Ms. Hunter to have access to her phone so she can call her father.
Your request is granted. All right.
Your Honor, just so the court is aware,
Hold on.
if someone bought them up prior to that,
They just what?
if someone comes before we are able to verify that, even the bond will allow them to be released.
Perfect. Okay, good luck, Ms. Taylor. Attila Angel Kennedy.
That's North Broward, Your Honor. That's medical recess.
Okay, thank you. Daniel Diaz.
Mr. Diaz is at the Paul Ryan facility.
Okay. Hello, Mr. Diaz. Mr. Diaz, you're here on a number of ad charges. It looks like a bunch of trespass and loitering and prowling charges. They're all municipal violations. State, what kind of priors does he have?
Just need his number, Judge.
His number is 796174.
Okay. It looks like it's all, or mostly felony drugs and some burglaries, all within the past 6 years.
Okay. Mr. Diaz, you have here 6 separate cases. 5 of them are trespass, 1 is loitering and prowling. If you'd like to resolve all of your cases, the court will offer you an adjudication and time served on each of your cases. In the alternative, you have bond set at $100 on each case.
I think no contest, adjudication, or time served.
Okay. The court will accept your plea of no contest. The court is going to adjudicate you guilty, sentence you to time served on each of your open cases. All right. Good luck.
Yes, ma'am. Thank you. Have a good day, ma'am.
You too. Jermaine Chanette? Yes, Mr. Linder?
North Broward, Your Honor.
Ma'am.
Yes. Hold on one moment. Hold on one moment, Mr. Chanette.
The 2 co-defendants we did earlier on the disorderly conduct, my memory is that you ordered no victim contact on both of them. I
Yes.
just want to confirm that because it's not showing on the findings of no victim contact.
I did order no victim
That's why I'm just
contact.
asking that so we can,
I did. I ordered no victim contact. Jermaine Chanette. Mr. Chanette, you're here on a battery charge and criminal mischief. These are 2 ad charges. The court does find probable cause. You have bond set in the amount of $1,000, and court is ordering no contact with the alleged victim, Yvonne Cowens-Smichael. Good luck. Jose Alvarez.
Mr. Alvarez is here present for the main.
Okay, thank you. Mr. Alvarez, you're here on a capias. There's a no bond hold. However, you do have court on May 31st. Good luck.
Judge, I'm speaking, Mr. Alvarez. I understand this is the case with the possession of cannabis. Right now, he is married. His wife is 8 months pregnant. She's bedridden at this time. She was working, but unfortunately, she had no sort of benefits. So right now, Mr. Alvarez is the sole financial provider. I believe it may be a high-risk pregnancy. This is his first child he's expecting, Judge. Right now, he takes care of her financially and as far as taking care of her, meeting all her needs right now. He's been residing in South Florida for 27 years. Judge, he's the one that pays the rent in the apartment. This is a 2010 warrant. I'd actually, Judge, at this time, if you would consider resolving the case for a withhold, take judicial notice of time served, Judge.
This is at a drug court. I'm sure if the public defender's office were to contact Judge Sellers, J.A., matter of fact, I'm checking right now. I'm quite confident.
What kind of priors does he have?
Probably none. That's why it's in drug court.
Judge,
I don't have a problem with him resolving this case.
thank you, Judge. I appreciate it, and he appreciates it.
Yeah, it does look like he missed court back in 2011, and the court issued this no bond hold. The court will offer a withhold in court costs.
Okay, thank you, Judge.
How do you plea, Mr. Alvarez?
No contest.
The court's going to accept your plea of no contest. The court's going to withhold adjudication and impose court costs. Good luck to you.
Thank you.
You're welcome. Gregory Parker.
Mr. Parker's here present, Judge?
Thank you. Mr. Parker, you're here on a violation of probation. There's a no bond hold. You have a court date on June 5th. Good luck.
This is 19.
Reggie Lee Johnson.
Mr. Johnson? Judge, this is a municipal ordinance case.
Okay, Mr. Johnson, you're here on a panhandling municipal violation. The court does find probable cause. If you'd like to resolve your case, the court will offer an adjudication and time served. Otherwise, there's a $25 bond.
Would like to resolve it.
How do you plea?
No contest.
Court will accept your plea of no contest. The court's going to adjudicate you guilty, sentence you to time served. You're all set.
Thank you, ma'am.
You're welcome. Lewis Ellis.
Mr. Ellis is here, man. He's approaching. Mr. Ellis here present, Judge?
Okay, Mr. Ellis, you're here on a capias on a trespass case. Stig, can you make an offer to Mr. Ellis to resolve this case?
One moment, Judge. Under state's offer would be time served.
All right, Mr. Ellis, the offer is an adjudication time served if you'd like to resolve your case.
No contest.
The court will accept your plea of no contest. The court's going to adjudicate you guilty, sentence you to time served. You're all set.
Thank you.
Okay. The court's going to take a 2-minute Anthony Marquez Bellamy.
That's North Broward, Judge.
Anthony Marquez Bellamy.
That's a North Broward medical reset, Your Honor.
Okay, thank you, Deputy. Trevor Mulcair.
Mr. Mulcair is here present, Judge Domingue.
Mr. Mulcair, you're here on a violation of probation warrant. There's a no bond hold. You have a court date June 5th. Good luck.
Yes, Your Honor.
Good luck, sir.
Samuel John Rennell Charles.
Mr. Charles is here present. He is approaching, Judge. He's asking Your Honor if you would consider resolving this case today.
Okay. But Mr. Charles, you're here on a capias, and the capias is on a suspended license charge, and then you have a ticket for operating an ATV on the road. Let me see if we could resolve your case. Hold on one moment.
Thank you, Your Honor.
Do you have any other pending suspended license cases, Mr. Charles?
Not that I know of. But, I mean, I did have tickets and stuff like that, but nothing.
Okay. I need to advise you that if you get 3 convictions of a suspended license within a 5-year time period, motor vehicles will revoke your driver's license for 5 years as a habitual traffic offender. Looking at your driving record, you have 1 prior conviction from November 2015, and this case would be your 2nd conviction within 5 years. If one of the outstanding tickets that are suspending your license happens to be a suspended license ticket, you got to be very careful the way you resolve that case, because if that's your 3rd conviction, you'll lose your license.
I understand.
Okay, now you do have a $500 bond, so do you want to resolve your case knowing what I've advised you, or do you want to just post bond and resolve and go to court?
That. So then bond out. If you financially can bond out, bond out, sir. Judge, respectfully, he's going to bond out.
Okay, very good. Good luck, Mr. Charles.
Thank you. Thank you.
Patrick Charisma.
Judge, I've been advised he bonded.
Thank you. Gabriel Victor Year.
I believe it's, oh, he's here. Oh, Mr. Yeri.
Oh, you could just use the same.
Mr. Yeri, come on up, please. He's coming up slowly, Judge.
Okay.
He's here, Judge, and this is a municipal ordinance case, Judge.
Thank you. Okay, Mr. Yuri, you're here on 3 municipal ordinance violations. One is a solicitation, one is failing to have the traffic vest, and the other one is failing to complete a traffic course. If you'd like to resolve your case today, the court will offer you an adjudication and time served. Otherwise, I do find probable cause, and you have a $25 bond. What do you want to do?
Resolve.
Okay, how do you plead, Mr. Yuri?
Guilty.
The court will accept your plea of guilty. The court's going to adjudicate you guilty, sentence you to time served on each of the counts. You're all set. You'll be released.
Thank you.
Floyd Sammy Argett.
Conti, Your Honor.
Okay. Ella, Mr. Argett. You are here on an ad charge for a grand theft. The court does find probable cause. You have bond set in the amount of $1,000.
Okay.
Good luck, Mr. Argett. Franklin Dossett. Hello, Mr. Dossett. You are here on 2 ad charges. One is a robbery with a firearm. The second is possession of a weapon or ammo by a convicted felon. The court does find probable cause, And State, do you wish to be heard on count 4, the robbery with a firearm?
So on count 4, Your Honor, the state is seeking a no bond hold. The state would argue under Brackett v. State, Isaza v. State, both out of the 4th DCA, that based on the probable cause affidavit, the allegations would support a finding of proof evident or presumption great for first appearance purposes only, specifically noting that the allegations would support the elements of robbery firearm, that Mr. Dossett was identified from the surveillance video which captured the robbery with the firearm taking place, and lastly, that Mr. Dossett, according to the probable cause affidavit, confessed to the robbery, specifically stating that he entered the store with a firearm, jumping over the counter, removing money from the register, noting that
Hold on.
noting that he provided information such as the location that only the person involved in the incident would have knowledge of.
Okay, thank you, State.
Don't say anything, Mr. Dossett, and don't say anything to anybody else either, other than your attorney. In light of the fact that Mr. Dossett is being currently held no bond on count 1, the defense would defer any argument as to proof evident presumption great at this time.
Okay, so Mr. Dossett, upon reading the probable cause affidavit, the court does find proof of guilt evident and the presumption great for you to be held no bond on the robbery with a firearm charge. On the possession of a weapon or ammo by convicted felon, the court is setting bonds in the amount of $7,500. Your attorney has advised the court that you're being held no bond on the other charges. I wish you luck.
And, Your Honor, we just ask for no victim contact, please.
Okay, Mr. Dossett, there will be no victim contact.
Can I speak to the court, please?
No, I don't think you should say anything, Mr. Dossett.
I would like to, please.
It's up to you if you want to speak. I'm advising you not to say anything. Everything you say is being recorded. Anything you say can and will be used against you later. You're facing life in prison on these charges. I strongly urge you to not make any statements at this time.
I would like to, please.
Go ahead, Mr. Dossett. This is against the advice of counsel.
I was on drugs. I've been on drugs. I never had this type of charges before. I don't even remember the things that I say. I don't remember the things that I know. I've been on Xanax. I've been on heroin. I don't know. I'm throwing my life. I go to school. You can even verify that. It was something that I've been on drugs for the last couple of months, and I don't even know what the hell I was doing. I'm fucking my life up. I don't know. Please give me a chance to at least go outside and keep my job and my school. And please, I don't do this type of things. I made a mistake once I was 19, and y'all can check my juvenile record. I don't never be in trouble. I don't do these type of things. Please.
Okay, Mr. Dossett, the court wishes you the best of luck once you go to the trial court, but everything is remaining as this court ordered.
Thank you.
Good luck. Wayne Ressid. Okay, hello, Mr. Ressid.
Good morning, Your Honor.
I've seen you a couple of times this week. It appears that you have some additional criminal mischief charges. I have read through the probable cause affidavit. The court does find probable cause. And at this point in time, let me advise you what the additional bond amount will be. It's going to be $2,625. Good luck to you, Mr. Ressid.
Your Honor, I'm sorry. What charges are we here on today?
He's got account 8, 9, 10, 11, 12, 13, and 14.
Okay, I wasn't sure because I have 8
They're
and
ad charges.
starting with 10. Are you just keeping the bonds in place as?
The original bonds are being kept in place. These are ad charges.
Yeah, that's what I just wanted to make sure. Your Honor, we would just the state would just ask that your no contact order you issued yesterday with regards to the Hollywood Police Department, unless he has official business, just be applied to these charges as well.
All right, Mr. Ressid, the same order that the court made yesterday as to no contact to the Hollywood Police Department unless you're there on official business is going to stand for today's cases as well.
Thank you, Your Honor.
Judge, the only question I just have to ask, I know we've been here, this is our third time, I believe, Hollywood is adding these additional charges. He currently, as you know, he's still in custody financially. Even the past 2 days of bonds that this court set, he cannot afford I don't know if this is from the same course of action, from the same incident date. Would you consider an ROR on 8, 10, 11, 12, 13, and 14?
State that.
Your Honor, we would oppose. Essentially, it's a request to mitigate based on committing more offenses. These bonds aren't, random. They're assigned to allegations of committing additional offenses of damaging property of Hollywood-owned property.
Well, the only thing I'm asking is if it stems from the same sort of incident from the same date. That's why I'm making that request.
Okay, your request has been noted for the record. The court is denying the request. I am leaving bond set as I stated.
Yes, Judge.
Robert Maddox.
Sure.
Mr. Maddox, you're here on a violation of probation warrant. There's a no bond hold, but you are going to court on May 31st. Good luck.
Good luck, sir.
Blake Oppenheimer.
Mr. Oppenheimer?
Hello, Ms. Oppenheimer.
Hi, ma'am.
You're here on a violation of probation warrant. You're being held no bond, but you are going to court on May 31st. Good luck.
Good luck, sir. May 31st.
Alkino Ferguson.
Mr. Ferguson?
Hello, Mr. Ferguson. You are here on a violation of probation warrant. There is a no bond hold, but you are also going to court May 31st.
Thank you very much.
You're welcome. Jeremy Hobson.
Mr. Hobson, come on up. He's in. Judge, I'm being advised that Mr. Hobson is in regular court.
Your Honor, I would just request this is a no bond hold pursuant to a warrant. There's nothing that can be done. He'll just be brought to his judge on his violation of probation. I would just ask that it be passed through.
Yeah, you're asking that what?
It be passed through, that he doesn't have to be reset on a VOP warrant.
Okay. Does the public defender have any objection to passing this through magistrate court, magistrate human absentia?
I kind of do. The reason being is because technically at magistrate court, individuals do the right to actually be read the basis of their violation at magistrate pursuant to Federal Rules of Criminal Procedure. Mr. Lunder, though, is right to no bond hold. So I'm not in a position to see what Mr. Hobson would actually want. So in abundance of caution, I would just ask you to reset it.
Okay, you do understand this is a violation of probation warrant with a no bond hold?
Correct.
Okay, then I will
Yeah, actually, Your Honor, he's
Yes.
in court before Judge Calra today for his probation status. He's going to know in front of Judge Calra what the allegations are.
Okay. If he's in front of his assigned judge for the violation of probation, then yeah, I wouldn't have a problem because he's actually being read what the allegations are today and he's being dealt with. But I know sometimes what happens is in the past, it's happened where Mr. Lender's made that request, we skip the person through, and basically the person has no court date on their violation of probation. We're actually dealing with one matter like that. So I don't want things to slip through the cracks.
Okay, and I certainly, I could appreciate your arguments, but since he is in front of the trial judge, the court's going to magistrate him in absentia, so he doesn't have to be brought back. He's here on a violation of probation warrant. There's a no bond hold. He does have a court date set on May 31st, although I know he's in court now. Okay, Michael Velez.
Michael Velez, come on up.
Hello, Mr. Velez. Mr. Velez, you're here on 2 violation of probation warrants. You're being held no bond. You are going to court May 31st. Good luck. Thomas Mezius. Hello, Mr. Mezius.
Good morning.
You're here on a violation of probation warrant. You're being held no bond. You are going to court May 31st.
Thank you.
You're welcome.
Judge, I'm being advised that I believe we skipped one gentleman that was on page 20, Ronald Salamanca. He was right before the VOPs were addressed.
Did I skip anyone? I don't. Hold on, I'm going to have my clerk look into it. Then his name is
Robert Salamanca, S-A-L-A-M-A-N-C-A.
Okay, we don't have paperwork on him. Why don't we have paperwork? He's being. The jail hasn't sent paperwork, so I'm going to ask that he be brought this afternoon. Should we have paperwork? All right, the jail's going to have to get the paperwork over. We don't have paperwork on him.
Ms. Reed, did you get any sort of paperwork? Because I know in the docket it usually says no paperwork and it doesn't have that.
I'm sorry, what?
I've got a booking sheet, that's it.
All right, he's going to be back this afternoon.
This afternoon? Okay.
Yes. Vidor Flurigine. Hello, Mr. Flurigine. Mr. Flurigine, you're here on a felony suspended license charge, and you have an out-of-county hold. I find probable cause for a suspended license, but not habitual, not felony suspended license. Does the state wish time to perfect? Actually, I'm sorry. I just read, I didn't see the probable cause affidavit before. I only saw the tickets. The court does find probable cause for habitual suspended license. It was the court's error earlier. You have bond set in the amount of $750. On the out-of-county hold from Miami, there's no bond hold. So you'll be brought to court to address your the felony suspended license charge. Good luck.
Good luck.
Anthony Anselmo. Hello, Mr. Anselmo.
Yes, sir. Good morning.
You're here on a possession of heroin charge. The court does find probable cause.
Judge, I would have to take issue with the probable cause in this particular case. The probable cause affidavit says that Mr. Anselmo was sitting inside the utility closet on a white bucket near a needle. We don't know how far away he was from that needle. We don't know whether there was anyone else present. We don't know whether there were any fingerprints on the needle, but being near a needle is not possession, at least under the 5 lines of the probable cause affidavit that we have in front of us. I think more detail is required before the court can make a connection between this needle and Mr. Anselmo.
Okay, state, wish to be heard?
Your Honor, the state is asking for 48 hours to perfect, 24 hours to perfect the PC affidavit.
Okay. The court will grant the state 24 hours to perfect the PC as far as the possession charge. You have a $1,000 bond. The case will be readdressed tomorrow. See if there's probable cause. Albert Ross Jackson.
Mr. Jackson, come on up.
Hello, Mr. Jackson.
Hello.
Mr. Jackson, you're here on a burglary of an unoccupied dwelling charge and 2 felony petty theft charges. I've reviewed the probable cause affidavit, and state, tell me how he's allegedly charged with taking a bicycle that was outside. Hold on. Why did I?
Your Honor.
Give me one moment. Okay.
Your Honor, Abner Laurent, on behalf of the state, the PC affidavit states that it was a fenced-in yard.
Right, that I understand, but what's the second petty theft? It was a bicycle.
There's a second PC affidavit, Your Honor.
Oh, I see. It's another. Okay. So it's a different date. Okay. So you're here on two different probable cause affidavits, Mr. Jackson. Just to clarify, the court does find probable cause. The court is going to set bond on count one in the amount of $5,000. Good luck.
And the state's
I'm sorry.
and the state's requesting no return to the property, Judge.
The court is ordering no return to the subject property. You have a $750 bond on each felony petty theft. Yes, let me hear from the public defender.
What we'd be asking you to consider is a $1,500 bond on count one and leave count 2 and 3 the same. That would be a total, if my math is correct, a $3,000 bond. And Steve, Mr. Jackson, he's been living in South Florida for over 30 years. He is 59 years old. Unfortunately, at this time, he's not working. He's in the process of applying for disability. He lives in Deerfield. He lives with his sister. They've been living in the same household for over 30 years. He has no money in the bank, no property. His sister's going to be the only person that could potentially post his bond. However, Mr. Jackson did advise me that financially he doesn't know if she's going to be able to afford a post of any sort of bond. And that's why I'd be asking you at this time to consider the $1,500 bond for count one, Judge.
Okay, thank you. State.
He's a registered sex offender.
I need for you to speak loud.
He's a registered sex offender, Your Honor. And this is from, along with the burglary of a dwelling charge, along with dealing in stolen property, grand theft, and false imprisonment.
There's a priors that he has?
Yes, Your Honor.
All right. Based upon Mr. Jackson's priors, the court is going to leave bond set at $5,000 on count one, $750 on count two, and $750 on count three.
Yes, Judge.
Jaquan Lightborn.
Mr. Lightborn, come on up.
If I could be heard for this finding.
Yes. Mr. Lightborn, you're here on a burglary with assault or battery charge and a domestic battery by strangulation. State, you'd like to be
With regard
heard?
to count one, Your Honor, I reviewed the probable cause affidavit, and I spoke with the alleged victim. I'm going to be asking the court to make a finding of probable cause for burglary of a dwelling. I don't believe the evidence would satisfy the legal elements that an assault occurred once Mr. Lightborn allegedly entered the residence. And I spoke with the alleged victim, confirmed that that once he entered, she immediately ran out. There wasn't any verbal threats. According to this, according to what she told me, he didn't chase her out, but it is certainly a burglary of her residence. Should the court, I'll wait for the court to make a determination, and then I'd ask to make a recommendation in regards to bonds.
Okay, so Mr. Lightborn, the state attorney's office has advised the court that what the charge should be is burglary of a dwelling, not the burglary with assault or battery. Is there anything the public defender wishes to say on that issue?
I know if Mr. Linder took the words right out of my mouth, I was going to make that argument myself, so I concur that it's definitely not a burglary with a battery.
Okay, very good. The court is in agreement, and the court does find probable cause with the burglary of a dwelling and the domestic battery by strangulation. And what is the state's recommendation?
The state is very concerned for the victim's well-being. As I mentioned, I spoke to her. She is very concerned for her safety. As Your Honor already is aware, there's serious allegations of the threats that were made previous to this incident. The alleged victim also advised me there was an incident last year where Mr. Lightborn shot her in the back with a I believe it was a pink BB gun. Your Honor, based on the level of violence alleged in this case and that the allegations he invaded her home and then committed an act of violence, I'm going to be requesting bonds on each count in the amount of $20,000, pretrial release with a GPS monitor, and no victim contact.
Okay, let me hear from the public defender.
Judge, in speaking Mr. Lightborn, at the state can verify, I believe this is his first arrest ever. He's 18 years old. He's currently going to school. He goes to Plantation High School. He's in 11th grade, will become a senior next year. Him and the alleged victim do not reside together. I believe she resides in Lauderhill. He resides in Lauderdale Lakes with his father. He's been residing, and him and his father have been residing in the same household for over 10 years. He's not working at this time. He has no money in the bank, no property. Considering, Judge, his lack of any sort of criminal history, his ties to community, his lack of financial resources, Judge, we'd be asking you to consider a $5,000 bond on count 1 and a $2,500 bond on count 2.
Okay, thank you. State, does he have any priors?
He has no adult priors, but he's 18. He was arrested. Well, he was arrested on a similar.
You need to go off.
I'm not going to go into detail. I'm not.
Okay. Okay.
Offense and to the actual offense. A similar offense last year, and I believe it might be related to the offense, the allegations I told the court about. That was dropped.
Okay. Mr. Lightbourne, the court is going to set bond on count 1 in the amount of $15,000. On count 2, I'm setting bonds in the amount of $20,000. The court is ordering that if you do post bond, you are to wear a GPS monitor from pretrial, and the court is ordering no contact with the alleged victim, Marquette Zander, and no return to the property. Hold on.
Hold on, Hector.
Hold on. Yes, Patrice? Mr. Lightbourne, are you in school?
Yes, ma'am.
You go to high school, you said?
Plantation High School.
Okay. With his monitor, he'll be allowed to go to school, absolutely. And the court will... Yes. I will waive...
What did you say, Hector?
Waive the costs. I'm going to waive the cost of the ankle bracelet, and the court is going to grant your request for photographs.
Thank you, Judge.
You're welcome. Ryan Christopher Sherwood.
Mr. Sherwood, come on up, please.
And Mr. Sherwood, you are here on a burglary of an unoccupied dwelling, grand theft, dealing in stolen property, and false ownership information given to a pawn store. The court does find probable cause. I am setting bond on count 1 in the amount of $10,000. That makes your total bond $18,000, and the court's ordering no return.
Judge, in speaking Mr. Sherwood, he's 35 years old. At this time, he's unemployed. He's looking for work. He was working last week cleaning pools. Unfortunately, he lost his job. He has no money to make, no property. He lives in Boca Raton. Him and his girlfriend rent an apartment there. They've been renting the same apartment now for 3 years. Their monthly rent is about $1,400. Judge, at this time on count 1, his girlfriend's not going to be able to afford the $10,000 bond. Judge, we ask you to consider setting a bond at $3,500 on count 1, similar to the 2 second-degree felonies as far as 3 and 4, which would then make it I believe, around my math is right. Let me do the addition. 35, 30, that's 7, 8. That would be $11,500 bond.
Okay, let me hear from the state.
Your Honor, this is a burglary of a dwelling charge.
I need you to speak up.
It's a burglary of a dwelling charge, Your Honor. And considering the facts of the case, the state is strongly recommending the $10,000 bond.
Okay, due to the nature and the circumstances of the allegations contained in the complaint affidavit, I am leaving bond set at $10,000. Good luck, Mr. Sherwood.
Yes, sir.
Angel Yacel Hector Vasquez.
Judge, he is here. He's going to require a Spanish interpreter.
Okay, let's put him on recall. And Madam Clerk, please get a Spanish interpreter. Oh, you'll call? Okay, thank you. Joseph Kopkovich.
Mr. Kopkovich? He's here, present, Judge of Maine.
Okay, Mr. Kopkovich, you are here on a burglary of an occupied structure and 2 counts of petty theft. The court does find probable cause. The court's going to set bond on count 1 in the amount of $5,000 and order no return to the subject property, the Seminole Middle School. OD.
The defense could be heard. And speaking of Mr. Kopkovich, he's 47 years old. He's been living here for 40 years. He's unfortunately at this time, due to the nature of the offense, his employment and I don't know if he's going to be receiving any sort of future financial income. He lives in Davie with his wife. They have 2 children, ages 10, 11. Judge, this is his first arrest. He's a registered voter. He's a veteran. He served our country in the U.S. Army for 11 years. After completing his contract with the Army, he then entered the National Guard. His date of service was completed in 2005. Judge, I understand the allegations. Mr. Kopkovich is looking forward to his day in court. There are going to be mitigating factors that will be sorted at trial or in future dates. But I'd ask you to take into account his very strong ties to the community, his service to our country, his family, and ask you at this time to consider a $2,500 bond on count 1.
State, can you tell me if Mr. Kopkovich has any priors?
Does pretrial have anything? It's not showing anything. Kopkovich.
Joseph Kopkovich. All right, the court's going to grant the public defender's request. I'm going to set bonds at $2,500 on count 1. You're welcome. Odiani Suarez Braz.
I'm sorry, one last request, and I forgot a phone order, and that's my, I apologize, Mr. Reedy, but we're going to be requesting.
Apology accepted, Mr. Romero.
Your request is granted. Okay, Odiani Suarez Braz.
Mr. Braz is going to require a Portuguese interpreter.
Just ordered one. They have one. Should be here soon.
Fantastic. Okay, let's put him on recall. Zachary Quinn Moore.
Mr. Moore.
Hello, Mr. Moore. You're here on a possession of cocaine charge. The court does find probable cause. You have bond set at $1,000.
Thank you, Judge.
You're welcome. Mark Vincent Cabral.
Mr. Cabral.
Hello, Mr. Cabral.
Hello.
Mr. Cabral, you are here on petty theft charge. You have a violation of probation warrants, 2 violation of probation warrants. You have another petty theft, grand theft, false ownership of info for pawn, and dealing in stolen property. The court does find probable cause. And let me tell you the total amount of bonds that you have. You have bonds on everything with the exception of 1 violation of probation warrant. You're going to court on May 31st. But at this point in time, in your other charges, it's $9,200. Good luck. Deandra Antoine Pompey.
Mr. Pompey is here present, Judge.
Okay, Mr. Pompey, you're here on a distribute cocaine charge. The court does find probable cause. You have bond set at $1,000.
Thank you, Judge.
Santiago Correa Ferrer.
I've been advised Mr. Correa Ferrer, bonded, Judge.
Thank you. Glenroy Odell.
I've been advised Mr. Odell bonded as well.
Okay, very good. Harold Alexander Arrieta.
Mr. Arrieta, Judge of the trifecta, he bonded as well.
Okay. Charles Tanner.
Mr. Tanner? Charles Tanner?
Hello, Mr. Tanner.
PC. Count PC.
Mr. Tanner, you are here on a grand theft auto charge and 2 resisting without violence charges. The court does find probable cause. You have a $1,000 bond.
Mr. Tanner is advising me that this is his first offense. If the state can confirm that, he's 21 years old, he lives in Hollywood with his stepbrother. Considering this is a non-violent offense, Judge, we'd be asking you to consider ROR.
Okay, State, does he have any priors?
State's asking pre-trial if he has any priors.
Don't be afraid to speak up.
We didn't hear what happened.
The State's asking pretrial if he has any priors. Okay. State have an objection to reduction in bond or pretrial?
It's fine, Your Honor. No objection. No objection, Your Honor.
To
I forgot to mention, registered voter in Broward County.
No objection to pretrial.
It's a pre-trial release.
okay, what the court's going to do, I'm going to release Mr. Tanner to pretrial.
He's your judge.
All right, Mr. Tanner, you live in Broward County?
Yes.
Okay. Well, the court's going to release you to pretrial. You're going to need to go over and sign up with pretrial once you're released immediately. If you don't, you're going to be in violation.
As soon as you get released, you just imagine you cross the street on 3rd Ave. If you don't show up, there's going to be no bond, all right? So go over there.
Mr. PTO.
All right, good luck, Mr. Tanner.
Good luck.
PC on all counts.
Willer Pierre.
Mr. Pierre?
Hello, Mr. Pierre.
Hello.
You're here on a violation of probation warrant. You do have a no bond hold. You are going to court on May 31st. Good luck.
Good luck, sir.
Timothy Terrell King.
Mr. King?
Hi, Mr. King.
Hello.
Mr. King, you're here on a violation of probation and a capias. There's a no bond hold. You do have a court date, May 31st. Good luck.
Thank you. Good luck, sir.
Stefan Antonio Newman.
Newman?
Hello, Mr. Newman. Mr. Newman, you're here on a felony suspended license charge, and you have a traffic ticket for liability security proof. The court does find probable cause. You have bond set at $750.
Judge, Mr. Newman is requesting you consider an ROR in his behalf.
What's the state's position?
Your Honor, the state objects. It's driving without license. The license was suspended.
They're asking
Don't
for
say anything, Mr. Newman.
an ROR.
Your Honor, he doesn't have priors, so the state doesn't object to ROR.
Okay, Mr. Newman, the court is going to grant your attorney's request. I'm going to ROR you.
Thank you, guys.
You're welcome. Berthani Login.
Mr. Login, come on up, please. Mr. Login? Yeah. Mr. Login, here. Sorry, he was being interviewed. I'm sorry.
Okay, Mr. Login, you're here on a grand theft auto, no valid license, and a fleeing charge. The court does find probable cause. You have bond set on the grand theft in the amount of $1,000. The court is going to set bonds in the amount of $2,500 on the fleeing. Good luck, Mr. Login.
If I could be heard, and speaking to Mr. Login, he's 18 years old. He's going to school. He goes to Terravella High School. He's a senior. Right now, he's going through final exams, and his expected graduation date is going to be June 6th if everything goes well with his final exams. He lives in Coral Springs. He lives with his parents. This is his first arrest. Judge, he did advise me he went out when he could to become a registered voter. If the state can confirm that this is his first offense, normally I would be requesting an ROR. However, I know the state's going to have concerns. They're probably going to raise it on count 3, and that's why at this time I'd be asking you to consider standard pretrial release for Mr. Login, considering all the previous facts I mentioned, Judge.
And what is the state's position?
Well, Your Honor, he's 18. So, yeah, he's not, does pretrial show if he has a juvenile record without going into details?
Are you Spanish or Portuguese interpreter? Spanish, Your Honor. Okay.
We'd also, there's a concern, as Mr. Romero spoke for me, and I would agree, on count 3, based on the nature of the offense, there is a certain concern about a flight risk based on him fleeing from law enforcement to avoid apprehension.
What is the state's recommendation?
Your Honor, on count 1, the state is requesting $1,000 bond, and on count 3, $2,500 bond.
All right, Mr. Logian, I'll tell you what I'm going to do. You don't have a prior record. You are 18 years old. I do have concerns releasing you to pretrial based upon the allegations that I'm reading in the arrest affidavit. The court is going to set bonds on count 3 in the amount of $1,500. I am going to reduce that bond. Count 1's going to be $1,000, so it's a total of $2,500.
Thank you, Judge.
You're welcome. Okay, we have our Spanish interpreter present. Recall on Angel Yasel Hector Vasquez. And Madam Interpreter, can you raise your right hand, please? Yes. You swear or affirm to translate from English to Spanish and Spanish to English to the best of your ability?
I do.
Okay, thank you. You're welcome. Mr. Hector Vasquez, you're here on a grand theft charge.
Señor Héctor Vázquez, está usted aquí por un cargo de hurto de grado mayor.
And you have a charge for passing a forged bill.
Y también está aquí por pasar un recibo falso.
The court does find probable cause.
Vemos que hay motivo fundado.
Bond is set at $2,000.
Y la fianza se va a imponer de $2,000.
Good luck.
Buena suerte.
Oh, thank you, Judge.
Okay, thank you. And I think that's it for Spanish. We just need the Portuguese interpreter.
Okay. I'll let them know in the office.
Thank you.
You're welcome, Your Honor. Have a
Danny Devon Alford.
Mr. Alford?
Okay, Mr. Alford, hello.
Hi, how you doing?
Good. You're here on a felony suspended license charge. You have a possession of weapon or ammo by a convicted felon, possession of cocaine. You have another felony suspended license charge and a violation of probation warrants. The court does find probable cause on the possession of a weapon by a convicted felon. The court is setting bond in the amount of $5,000. There's a no bond hold on your violation of probation. You are going to court on May 31st. With the exception of the no bond hold, you have bonds set in the amount of $7,500. Good luck. Shaquille Takan Brown.
Mr. Brown?
Okay, Mr. Brown, the booking was corrected, and thank you. Okay, so the booking was corrected to robbery by stud and snatching without a firearm. And then you have a violation of probation. Okay, is there a recommended, I'm sorry, the court does find probable cause. Is there a recommended bond on count 1, State?
Your Honor, because Mr. Brown was out on probation for grand theft when he allegedly committed this offense, I was going to be requesting a $7,500 bond and no victim contact.
Okay, does the public defender wish to be heard?
He works at a car wash. He gets paid about $40 a day. Judge, considering he has a no bond hold on count 2, we'd be asking you to consider $2,500.
Okay. The court is going to keep bond, actually the court is going to set bonds in the amount of $7,500. The court's going to order no contact with the alleged victim. And you are going to court May 31st, as I mentioned. Good luck. Kenneth Lindley Hodge.
North Broward, Judge, I believe.
Okay. Hello, Mr. Hodge.
Good morning, ma'am.
Mr. Hodge, you are here on a failure to register as a career offender. The court does find probable cause. You have bond set in the amount of $5,000.
Ma'am, I don't
Yes.
understand this. I don't understand this in no way. I was never made aware that I had to sign up, and then I haven't. I haven't.
Mr. Hodge, I really encourage you not to say anything about the facts of your case.
Okay, so what I'm supposed to do? Just sit here?
At this point in time, Mr. Hodge, bond is set at $5,000.
I will resolve this somehow, ma'am.
Okay, we can't do that in bond court. This is a felony.
But what did I do wrong?
You are here on a failure to register as a career offender.
I've been out for a whole year. I haven't been arrested. I haven't moved anything.
Mr. Hodge, if you apply for the public defender's office, you could speak with your attorney about any defenses that you do have and see how to handle this case.
So how do I get out today? How do I resolve this now?
You're not going to resolve it now. Good luck,
Ma'am,
Miss.
I have a show tomorrow.
You have a what?
Show.
A show. Okay. Well, you have a
Tomorrow.
You have a $5,000 bond, Mr. Hodge. That's what is existing right now. Good luck, Mr. Hodge. Emmanuel Colon.
I have a $5,000 bond for what? What did I do wrong?
I advised you, Mr. Hodge. I'm not repeating it.
Tell me what did I do wrong?
You failed to register as a career offender.
Where? I haven't been in touch with the Department of Corrections over a year.
I need to see Emmanuel Colon.
Man, hold it. I'm asking you. But it's ridiculous. They tell me I gotta be arrested with who?
Where is Emmanuel Colon?
He's also in North Broward, Your Honor.
Oh.
Jesus, man, it's crazy, man. How can I
Hi, Mr. Colon.
How you doing?
Well, thank you for asking. Mr. Colon, you're here on a burglary of an occupied dwelling, criminal mischief, and you have some court orders for your pickup, and there's a violation of probation or community control. The court does find probable cause. The court is setting bond on count one in the amount of $7,500. On the criminal mischief, it's $25, and you have no bond hold on the other warrants and court orders. You are going to court May 31st to address those.
So the first, the new charge I have is $25?
No, I said $7,500 on the burglary. On the criminal mischief is $25.
The criminal mischief, that's the one that popped up, right?
You have two.
Your Honor, the state's requesting no return to the property.
The court's going to order no return to the subject property. You're going to court on May 31st.
Okay, why is that a criminal mischief on the same case?
These are two charges that are contained in a capias, Mr. Colon. And it looks like, hold on here.
Supervisor Court, he'll be scheduled for arraignment rather soon now that since these are filed charges.
Okay.
So
Hold on, I'm going to let you know. It says here, the allegation is that once you were inside the house, you damaged property in the amount of $200, which was a video surveillance camera, and that you took a metal rod-type object to damage it. That's the criminal mischief, Mr. Colon. Good luck.
okay, thank you.
You're welcome. We have what? Okay. Cesar Daniel Lopez. This is a case that was for perfection. We still need the Portuguese interpreter. Oh, we have her here. Hello, Miss Barbosa. Hi. Okay, Mr. Lopez, on the possession with the intent to sell or deliver heroin, the state able to perfect? All right, so Mr. Lopez, on count two, the possession with the intent to sell or deliver heroin, the court is going to ROR you on that charge.
Thank you, Judge.
You're welcome. Okay, recall on Odiani Suarez Braz. Okay, Madam Interpreter, can you raise your right hand? Do you swear or affirm to translate from English to Portuguese and Portuguese to English to the best of your ability?
I do, and my name is Susan Dix Barbosa for the record.
Okay, thank you, Ms. Barbosa. Mr. Braz, you're
Senhor
here on a
Braz.
using a false info for a driver's license.
O senhor está aqui para acusado de usar informação falsa para tirar uma carteira de motorista
Making false statement to Driver's License Bureau.
e fazer uma declaração falsa para o Departamento de Carteiras de Motorista
Fraudulent use of ID of another person.
e utilizar a identificação de uma forma fraudulenta de uma outra pessoa
Possession of a forged license.
e possuir uma carteira forjada, fraudulenta.
And a false statement to obtain Social Security.
E fazer uma declaração falsa para obter um número de seguro social.
The court does find probable cause.
A corte determinou que tem motivo suficiente.
Bond is set at $4,100.
E tem uma fiança, $4.100.
Good luck, Mr. Braz.
Então, tudo de bom.
Judge,
Yes.
if I could be heard, I don't know if the state can, I don't know if Mr. Braz, I don't believe he has priors, but I don't know if the state can confirm. He lives in Boca Raton. He and his roommate rent a house for approximately $1,600.
State, does
Judge, he works in construction, only making $10 an hour. I'd ask you to take financial resources into account.
Okay. State, does he have any priors?
Só perguntou se você tem antecedências.
All right, so what's the state's position as far as public defender's request?
Está perguntando o que o promotor acha a respeito
Your
do
Honor,
pedido.
the state is requesting that the bond amount be kept in place. He has a no valid driver license, since in 2010.
Okay, Mr. Braz, due to
Senhor
the
Braz,
nature of the
por causa de
allegations.
Oh, I'm sorry. It's different on the. I can't do it at the same time as you.
What were you doing?
I was doing it simultaneously. I apologize.
Oh, no, that's okay.
Okay.
Due to the nature of the allegations, Mr. Braz, the court is going to leave your bond set at $4,100.
Por causa da natureza das acusações, a juíza vai manter essa fiança no valor de $4.100.
You certainly do have the ability to file a motion for reduction of bond in the trial court.
Mas na corte de julgamento, você tem a capacidade de dar entrada num pedido para reduzir o valor da fiança.
Good luck, Mr. Braz.
E boa sorte, Sr. Braz.
Okay, thank you. We are all.
Judge,
Yes.
Are we going to start at 1 o'clock today? On Fridays?
Yes, we are going to start at 1 o'clock.
Perfect.